All right, good morning, everybody. And we're going to hear from the prime sponsor of this wonderful bill. Which one is it, by the way? 299?
That's all good.
All right.
Well, good morning, Mr. Chair, and members of the committee. For the record, my name is Senator Howard Pearl. I reside in the town of Loudon and represent the voters of District 17. I'm here today to introduce Senate Bill 299. So currently, the existing penalty provision in the Shoreland Protection Act does not adequately address professionals such as contractors who are willing to complete a job without the necessary permit or who ignore the approval criteria in an obtained permit. In such cases, the contractor receives an unfair advantage over more reputable competitors, and the landowner is left with the ramifications of correcting the violation when DES makes them aware. Many property owners rely on contractors to know what type of work is allowed under the law and what permits are required to do the work. Most contractors follow the law and work with the property owner to develop a project that will qualify for a shoreland permit.
The sign-up sheet. Sorry.
However, there are a few bad actors who regularly cause violations without the knowledge of their clients. Under RSA 483B18, as currently written, we can only pursue an administrative fine or penalty under the Shoreland Protection Act if there is a failure to restore the site within a year after the agency has provided notice of the violation. If there is a failure to restore, DES can pursue an enforcement action against both the property owner and the contractor. However, if the property owner appropriately cooperates with the agency to restore the site after receiving notice of the violation, DES has no mechanism to bring an enforcement action against the contractor who did the actual violation. Additionally, the property owner might pay the same contractor again to do the restoration work on the property. This amendment is meant to close that loophole. So I hope you will support it, and I know we have a member from DES here who can answer technical questions if you have some.
Thank you, Senator. Are there any questions from the committee? Seeing none.
Thank you.
Darlene? Oh, I guess you do.
Oh, hold on. I almost
Apologize.
got one.
Thanks, Mr. Chairman. So Senator, at the end of the bill in section 3 there, notwithstanding the $5,000 fine limit in subparagraph B, the administrative fine for each repeat violation of this chapter may be multiplied by a factor 2 for every previous violation committed by the person or entity.
Mm-hmm.
So, do you have any sense of how that would it have to, if that violation was, if there was a violation that was still being adjudicated, or how is it that this is going to be tracked and defined?
I'm actually going to let DES answer that. I think they'll do a better job of it since they actually do it. But I think the the reason for it is to really put some teeth into this and hopefully compel people to do the right thing and follow the laws.
Thank you.
Darlene?
All right. Thank you.
Good morning, my name is Darlene Forst. I am the current Wetlands Bureau Administrator at the New Hampshire Department of Environmental Services. Prior to that, from 2001 through 2021, I had been the Shoreland Section Supervisor at Environmental Services, so I might be infinitely familiar with this issue. I did pass out a written letter of testimony. We did email this late last night, but on the outside chance that you haven't had a chance to check your email and go through it this morning, we did provide a written copy to you folks. Formally, the department is not taking a position on this bill. With that said, though, we very much would like to thank Senator Pearl for taking this and bringing it forward for discussion this year. I can attest to the fact that this is in fact a very real issue, and part of what I would offer in support of that is the number of times that I have heard complaints from contractors who do the work right, who go through and tell people you need a permit. They put a bid in on a job and tell them you'll need a permit. Some of them are also consultants, some of them are not. And then a few weeks later, they're moving by the site, going to another job, and they notice that someone else is doing the work, and they know that there's no way a permit's been pulled. And that has offered an unfair advantage to a competitor who's willing to take that money and clear off the site, get the job done and clear off before they're gonna get caught. Inevitably, those things are frequently caught and they're sent to us as a complaint, and often it's an out-of-state homeowner or a second home for someone because it's waterfront. And that person has relied on the fact that the contractor said they did it right. So unfortunately, the way the law is written right now with regard to penalties, the ability for us to fine is directly tied to not having completed restoration within a year. Often that homeowner might not want to be associated with that contractor for another year, or they can't get the guy to return their calls. And then it comes down to what is restoration. If the contractor's not party to it anymore, they can say, well, it's not my fault, the restoration's not been done, what are you fining me for? So this is a very real problem. It does offer a competitive advantage, and frankly, that doesn't seem fair to some folks.
Questions from the committee? Senator Rosenwald.
Thank you, Mr. Chair. My question is just sort of procedural. Why did this need to be a late filed bill? Why, if it was a problem, wasn't it a regular filed bill? What happened between early January and now?
I think there have been quite a bit of discussion about this as early as possibly December, but I also think that this has been a rather chaotic couple of months with a lot of things going on, and I can't answer for who could have possibly filed it earlier or not filed it earlier, but we do very much thank Senator Pearl for getting it in as a late item at least for this year.
Thank you.
Mr. Chair, if I might.
Yep.
Senator, DES came to me with this literally at the 11th hour, and I didn't have the bandwidth to put it in at that point because there was still one or two minor technical corrections that we identified that we wanted to work on, and I just asked them to make sure we had everything done correctly and that I would do it as a late file bill.
Okay, so now it's always the plan.
Yeah.
Thank you.
Any further questions? Senator Waters.
Yes, I think you heard my earlier question. I just wondered about the kind of administrative procedures about determining whether someone was a repeat offender and whether the adjudication for a previous violation at what stage it would be at for you to be able to have that enhanced fine.
The determination on that for us, I believe, would be if we had someone with whom we had an active violation, so that we were in an active enforcement and compliance process. And we determined that prior to them being notified that this was a violation and that they had an issue, they had also committed another violation and we found out about it at the same time. Well, that wouldn't be fair because those things were done before they were notified. But if we have an individual who we are in an active enforcement proceeding with, and a month, 2 months after we've started that active enforcement proceeding and we know that we've had interactions and they're aware that things were not appropriate, they go out and do it again, that would be probably a situation where we would talk with our legal counsel about whether or not it was appropriate, depending on how egregious. Was it in fact the same exact thing that they've done again? That would be the kind of things that we would consider.
If I may follow up. I guess the concern of my question was this, that if someone can appeal the determination that they're in violation or not, so that if there wasn't a final determination that a previous violation had occurred and there's another activity that you consider a violation, I'm just concerned that enhanced fine might be put on someone for whom there had not been a final determination of the previous one.
And that is why we have some of those legal attorney types on staff now, because I would probably be the one who is a little bit, yes, I can't believe you've done that again, and ask them if we should consider doubling the fine for the second violation, and they would probably tell me exactly what you just did, that might not be appropriate.
So if I may just follow up. So, I don't understand perhaps the wording sufficiently, but would it be possible to say something of a previous violation for which there has been a final determination?
if we haven't finished, as you, in the situation that you mentioned earlier,
Yeah,
if they are in appeal and they contest what they did was never illegal, that they shouldn't have a fine, then as worded, I trust that our legal staff would step in and tell us that until they're actually found to be in violation and that violation sticks and it goes all the way through the appeal process, they wouldn't let us apply it a second time.
thank you, and I would suggest maybe, Mr. Chairman, I mean, I agree with your interpretation, but I would think maybe that sentiment might be mentioned in the floor remarks so that we have a record on the floor as to the intent of our interpretation of
So perhaps we could put it in our committee report?
Yeah,
That would,
well, is the committee report the legal standing, or is it just what's said on the floor?
I know we've always considered that to be a part of it, at least. We want to be careful, make accurate, make sure that our committee reports reflected the will of the committee. Because I do know I have heard at least that they've been reviewed by judges.
Okay,
when they're looking
fine,
at it.
thank you, so that would be sufficient.
Senator
Thank you.
Rosenwald.
Thank you, Mr. Chair. So, I'm new to this committee. Am I right in reading this so that both A and B could apply? So the Superior Court could give the contractor a $5,000 penalty, and DES could also do the same thing, so that an unscrupulous contractor could actually be required to pay $10,000.
Yes, ma'am, both A and B could apply.
Thank you.
Further questions? Seeing none, thank you very much for your testimony. Does anybody else want to talk about this? Griffin, I see you're here.
Oh, no, I'm good.
Just needed a place to stay.
Yep.
It's nice and warm in here.
Can you see it? You want to talk about shoreline?
All right. With that, we'll close the hearing. Do you want to wait for Mark to get here before we exit this? or-
He and I may cross paths. I have to be in election law in about 15 minutes.
All right, so is there a motion to move into exec?
So moved.
Second?
Seconded. Okay, all in favor, aye?
Aye.
Any opposed? I guess what we have,
You want to do 299?
299 first.
All right, I'll move on to pass.
discussion, second? I'll second. Discussion on 299.
Well, I would just say I want to reflect in our committee report and make sure we do what Senator Waters raised for concern, because I think it's important.
Hey, can you repeat that?
I'll actually let Senator Waters repeat it since he knows what he wanted to say.
Yeah, that, the committee report should reflect that. We determine a violation that might precipitate an enhanced fine for a subsequent violation to be a violation that has reached its final resolution of or its final determination.
Sound good to you?
Absolutely.
Yeah.
Well, I certainly trust the department wouldn't do that, but I think it's always good to have legislative intent determined.
Yes.
So thank you for bringing that detail.
All right. So all in favor of ought to pass?
Aye.
Any opposed?
Consent?
Consent? Seconded by Senator Avard. All in favor of consent?
Aye?
Aye.
And,
I'll take this out if you want.
and Senator Pearl will take it out. All right, so 237, let's, I know we're missing a member, but
I can explain what.
there is there a motion of ought to pass for the
Yeah, I
discussion?
move up to pass on Senate Bill
Seconded by Senator
237.
Rosenwald, and there's an
And I
amendment.
move amendment 851.
Seconded by Senator Avard.
But I think it's gonna become a committee amendment. So, you recall in the hearing on this that, we had discussion about when it might be appropriate for the Office of the Consumer Advocate to participate in site evaluation. And I think that we heard, some real concerns from Eversource and others, and folks that were afraid that this blanket determination might, slow the process down, and then some conversation about whether or not it was really appropriate for the Consumer Advocate's Office to be involved in site evaluation decisions. During the hearing, the suggestion was made by Senator Pearl that perhaps the way to handle this would be to say that if the counsel for the public who was involved in the site evaluation committee process determined that there was a relevant interest for the consumer advocate that would be related to the actual job of the consumer advocate, which is to protect ratepayer interests when it comes to rates, that perhaps we could have wording that said that if that determination were made, the counsel for the public could request that the consumer advocate would be involved at that point. So it narrows things considerably. And I think it is a, we did hear from the Department of Energy, from Chris Elms, that they had no real problems with this bill. And I think that this then is a form that addresses the concerns of the utilities and also the concerns about when is it appropriate for the consumer advocate. Looking at the way this amendment is drafted, I think that what we would need to do, I think it was meant to be in a replace all, because I don't think in the original bill on 237, where you'll see part 1 adds in bold that word facilities. Since we're doing this process, we don't want to then add facilities to the language around the duties of the consumer advocate. So essentially it's saying there's a special case in which the public counsel would say, now you do come in and say something about facilities, but it is not part of the general duties of the consumer advocate office. So folks, that's the gist of it.
Okay. Comments from the committee?
Question.
Senator
Thank you.
Rosenwald.
Is the counsel for the public, are they always involved?
Yes,
Every time?
that's their
Okay.
job.
Thank you.
I asked Drew to be here. You have a couple of comments that you wanted to, if you don't mind. I know there was another individual, Mark Brown, was very concerned about this particular bill as well. Yeah. But you got the amendment, and basically the amendment is a replace all?
It will, I would like it to be, yes.
So is this on?
Yes.
The amendment doesn't really change my opinion on the bill because it doesn't.
Just, who are you?
Oh, I'm sorry. I'm Drew Beamer. I'm the administrator of the SEC. I had some brief prepared comments, and then maybe I could talk to the amendment specifically.
By all means.
Members of the committee, thank you for the opportunity to testify. First, I wanted to thank everybody, not just in this committee, but also in the House STE, because we've done a lot in a bipartisan fashion to make this whole thing a lot better over the past couple of years. And I know unequivocally that everybody involved here is trying to do things that are going to make the process better. So the OCA provides a very invaluable service to energy policy discussions in New Hampshire. And I very much appreciate the intent here of this bill. However, I have concerns about how it would impact the SEC's role. The SEC is a land use body, not a rate-making body, and expanding the OCA's role in these proceedings would also expand the SEC's authority to evaluate rates as a criterion for project approval. And while that might sound reasonable, the SEC is not the right place to have that discussion at all. Decisions about electricity rates are made at the regional level. New Hampshire ratepayers contribute 11% always to regional transmission costs. Much of that goes towards projects outside of the state. They build something in
Did you say 11?
11%.
Oh, it went up?
I guess, yeah. It's, what did it used to be?
10.5.
10%, okay. And if the goal is to advocate for ratepayers, the appropriate venues are FERC and ISO New England, where the cost decisions are actually made, not at the SEC. So as administrator, I've always sought to keep us very focused on our core mission rather than expand the authority of the SEC. Changing our mandate to include rates would shift project approvals away from siting and environmental factors and introduce considerations that, in my opinion anyway, were never meant to be part of the review process at the SEC. I appreciate your thoughtful approach to all this stuff, and I would love to answer questions.
Yeah, so Senator Waters, you have questions?
Yeah, I do, and thank you, and I agree completely that the process we went through the last couple of years to create the new SEC process was really a good one. What I do believe, and would you agree with me, that it seems to me rather obvious that sometimes the siting of a facility, as it relates potentially to interconnection issues and so on and so forth, and the nature of the facility itself, may impact customers, residential utility customers, so that if there is a circumstance in which that's the case, doesn't it seem appropriate that if the public counsel says, well, there's somebody who really has expertise on this, it's consumer advocate, and we ought to hear from them?
Not to the SEC, to FERC and to ISO New England, because the rates on this are determined at the regional level. So the SEC has not ever had, and in my opinion, should never have, rates as a consideration, because FERC approves the tariffs by ISO. ISO determines which projects qualify for cost reallocation. So if you build something in New Hampshire, it still needs to be approved by ISO New England for cost reallocation. And they could very well say that they're not going to let Eversource, for instance, reallocate those costs. So that all happens at the regional level.
If I may, Mr. Chairman. Yeah, I understand that. However, I do not think that siting and rate making are two black boxes that are apart from each other. And so that, I think that there was concern here that there are consumer interests that may, in certain cases, and I can think of some, might be appropriate for the consumer advocate. So there are a lot of guardrails here, aren't there? That it has to be the public counsel.
Yeah.
Thank
What
you.
would ease your pain if you wanted to amend this amendment?
It's a good question. I'm going to fall back on the position that I don't think rates should be a criterion for siting and permitting, because we as a state have no authority over that. When they build a project in Massachusetts, we pay 11%. When they build one in Connecticut, we pay 11%. When they build one in New Hampshire, we pay 11%. And that's determined at the regional level via ISO, and then it's approved by FERC. I would also ask folks to consider the generation component here. We've been focusing on transmission upgrades because those are a little more nebulous, you know, they're interstate, who do they really benefit? Imagine a world where this passed and we had a wildly unpopular transmission project, possibly coming from Canada into the grid. And there was opposition by local towns along the route in the form of warrant articles and in the form of, you know, resolutions. But in this world, we're using rates as a criterion to judge the fitness of hydroelectric power from Canada. It could tip the balance, the rate conversation could tip the balance in favor of an unpopular project. It could also tip the balance against a popular one at the SEC, meaning if you had a utility scale solar array that was being developed and the town liked it and the landowners liked it and the political class liked it, but what it ultimately came down to was that it was going to raise residential rates. Would you want a potentially good project by, you know, other policy criteria to fall victim to rates at the SEC being the deciding factor? That would be, and I understand that the transmission thing is a little more of a moving target, but I honestly believe that rates under any incarnation belong, transmission rates belong at the regional level.
Okay, Senator Rosenwald?
If I'm looking at the amendment proposed by Senator Waters, there is no requirement that the consumer advocate get involved. It enables the consumer advocate to get involved. So the public council could determine that rates were going to go up, and the consumer advocate could still say, I'm just not going to even go there.
The consumer advocate can presently solicit the input and help from anyone he wants to. So he currently could solicit the advice of the consumer advocate as part of his investigative team for any project.
This doesn't change his role in any
So the question I have here, would this allow the OCA to be a second intervener, or would he be a co-intervener with the counsel for the public as a single entity?
I think that's answered in the second
Okay.
paragraph.
May compel consolidation of representation. Okay. I'm still not in favor of it. Apologies. I honestly fear the unintended consequences of this, and
So we're basically inserting our role into ISO with this bill, which, is there any other instances where we've done that?
Well, I'll tell you this, is I honestly, as far as OCA functions that fall outside of the SEC, which is obviously quite a few, right? I'm not familiar with what Mr. Crease does outside of the state of New Hampshire, so I can't speak to that. But hypothetically, a very good function of an OCA at the state level would be to advocate for New Hampshire ratepayers at the regional level and argue two ways. First of all, say perhaps we're paying too much of the cost reallocation for projects that are made in Massachusetts and Connecticut, but then also possibly arguing that a project in Massachusetts or Connecticut shouldn't get cost reallocation at all because there may be no benefit to New Hampshire. So those are two mechanisms that the OCA can use currently. And again, I'm going to go back to the first thing I said. The OCA as an office and as a current office holder are super valuable, in my opinion, to everything energy related. And I also understand that if you're someone with advocate in your title, you are going to try to accomplish your mission at every level afforded to you. And I would never fault someone for feeling that way. But as the site evaluation committee, I've really been trying to dial in the focus of what it is we do in our silo over here. And we are a siting and permitting body that looks at environmental impacts and view shed and noise and landowner concerns. And I do not feel that the OCA is an appropriate office to intervene here at the SEC. And the counsel for the public is obviously ratepayers are a subset of the public. And the counsel for the public and the AG's office do an outstanding job of advocating for whether or not a project is, quote, good for New Hampshire. So, they're looking at a project holistically, and they're saying, is this project good for New Hampshire? And they do a very good job, and they call balls and strikes. They really do. I don't always like their position, as you can imagine, but they always call balls and strikes.
Interesting. Questions?
Thank you. Thank you, Mr. Chairman. I apologize for being late here. Last time we revisited this, am I correct that we were looking at an amendment that might involve going to the Attorney General to be included into it? And now we've gone past that, and now we're saying that they may appear in any instance?
Are we back in
Am I-
the executive without Mr. Beaver now?
Yes. Thank you for you have anything else you want to add?
Oh, no, sir.
All right, that's good.
Thank you.
Okay, yeah.
So, thanks for the question. So, Don went to talk with folks, Attorney General's office and so on. And this is and the public counsel, and this is the language that if you said the sense was that this is the way it was going to be done. that the public counsel would be the appropriate person to make the determination. Now, the Attorney General's office did not particularly want to take a position or get involved, but this language then that, you know, that was developed in consultation with the public counsel office.
Okay,
That
thank you.
seemed like that was the
I
appropriate
just
one.
wanted to
Yeah.
make sure my
Yeah,
recollection
yeah.
was correct.
And,
Thank you.
because that was a suggestion from Senator Pearl, you know, what about the Attorney General? But it seemed like, well, if somebody's gonna make the call, the person who's officially designated in the SEC process is that public counsel, as we heard in the hearing. So that's why it came forward like this. And I would just note that the notion that the consumer advocate can, you know, request information and so on and so forth, that's not really the case unless, I mean, in a recent, you know, in a recent situation which the consumer advocate wanted to be able to provide testimony in a process, they were told, no, you can't. So that's why this bill is there, to make sure that we have this kind of opportunity for transparency and for consideration. And it doesn't take long to think about the siting of projects in the state for energy, whether you go back as long as I do into Seabrook in the 70s, that there are impacts on ratepayers, decisions that are made about where to site projects. So
Does the SEC set those rates? Have they?
I think that we focused on ratepayers almost, I mean, I think it says residential utility customers here. So that the consumer advocate, if requested by the public counsel, would be able to answer some pretty particular questions about, is there anything about this project that might affect utility customers, which is the criteria whereby the public counsel, you know, thinking in their investigation of it, that there at least ought to be some information about that potential at this stage. And this kind of bifurcation about the rate setting from the construction, I understand there are different functions here, but I think the point is that there are times in which that lens needs to be applied to this as well.
How would they go about setting that up? How would they go about determining what the rates are gonna be?
They never would. But what it might be is the consumer advocate, at the request of public counsel, might come in and say, well, the nature of this project and where it's being built and what we've seen in other states might lead one to think that there will be an impact or not, right? The consumer advocate might say, no, there really wouldn't be any impact. Or it might be a positive impact, but it's just you have an opportunity to check there, because rates are not set by the SEC, no.
Right.
And there wouldn't be asked to under this.
Would this have the potential of slowing down or gumming up a project?
I think it's quite unlikely, because it would be under the public counsel's determination that we ought to at least have this information. And there are deadlines, you know, when we revise the SEC process, there are deadlines there. So this would have to function within that.
All right, do you mind if I mull this over for
No, we don't need to act this week.
Okay.
And
Next week?
I suggest you might give a call to Chris Elms.
Yeah, I'll do that.
Okay.
I'll do that. I'm kind of, in
Yeah,
a fog
that's
on this
fair
right
enough.
now.
I just wanted us to have a conversation and,
Yeah, and I hate to slow that down, and I know you do a lot of yeoman's work on a lot of stuff, so.
no, it's good, it's good.
Are you,
Here we are.
are you comfortable with
I'm comfortable with waiting.
waiting?
Thank you.
I appreciate that. Senator, you're okay with that? Just another week, which means we have to meet again. Sorry about that.
If I might mention something else, Mr. Chairman.
Absolutely.
I communicated with you about the amendment to Senate Bill 170 that's being heard in Commerce at 11 o'clock.
Yep.
And I noted that this is a late filed, I mean, this is a non-germane amendment, it's having a hearing. And I just wanted to note that it includes provisions that were in the bill that we heard that we found many problems with, and now they've been grafted into here.
You got that? Oh, just so that's on record, though.
Yeah, so I just wanted to call to people's attention, this is on the road, to limit road frontage requirements, setbacks for wetlands and lot lines to no more than 50 feet to improve housing density. This is the language and the language here also has some of the same problems. And I will note that
And the bill number is?
it's a non-germane amendment to Senate Bill 170. And
I
I'd
just want
also-
that for the record, so that.
and I'd also note that it also has a provision, prohibition on blocking development to rare species sightings. Notwithstanding any laws to the contrary, state agencies shall not forbid or delay any proposed development due to reported sightings of rare plants or animals if such sightings occur more than 5 years after the date of the development application. So think what you may, but this is the Endangered Species Act, the federal law, state law, and I'm not sure that that is particularly legal, but again, it's what we also looked at in the bill that was in this committee, we decided to retain. So now it's popped up on this in another committee, and I'm gonna talk to Senator Murphy, but I just want to bring it to attention because I'm not, familiar with a case where something is not worked in one committee, it's then brought over to another, which wouldn't really have any expertise on dealing with these
Right.
matters. So I just, whatever. I mean, we have a lot of opinions about things, but I thought at least should be the attention to this committee that this is what's.
Senator Pearl, I just want to get you, can you update again, because you walked in late, but
I did, sorry.
there's a non-germane amendment that's in Commerce?
Yeah, at 11 o'clock on Senate Bill 170, and it includes the wetland setback provision that Senator Murphy had in the bill that we retained, and it also has an endangered species provision, which I think is problematic. And, they were in that other bill, and we heard all the problems about it, and now they've been put into this one. It's in Commerce, so just want to let people know.
No.
No, I mean, I just
No,
want
no.
people to know. It is a little bit of committee shopping, but, it's just, here we are. Just thought you ought to know.
Okay, thank you. All right, any further discussion? Do we have anything else that we need to exec today? Actually did a great job. Yeah, so we're not gonna exec this one today. We're gonna push it off one more week.
2:37?
Yeah.
Yeah,
I just need to have a little bit more discussion. and
Fair enough.
Need to talk with Chris Elms and a few other people, but I just want to, I'm just kind of,
Well, we want to make sure we get it right, and we have time to do it.
Yeah, I mean, we'll see.
Yeah.
I mean, I understand all sides of this. I do think there is some tension around a lot of things going on with the PUC and SEC, as you will hear.
Yes, I'm sure.
So that's all. And I don't, whether this is where we ought to go or not, the wisdom of the committee.
well, you're part of that wisdom, sir. I really appreciate everything that you do.
Some days.
Yeah,
Well, you much more eloquently put my words on paper than what I presented you last week.
so with that, seeing how we have no further discussion, we'll look at this next week. All right. And,
Move we exit executive session.
seconded by Senator Rosenwald, all in favor of out of exec?
Aye.
Any opposed? Any other further business? Nothing before we close? Okay, we're out of here.
Thank you.
All right.